One, he's supposed to represent the people of Juja constituency, and there is a legitimate expectation.
I think we are going back again. I think
It is submitted on it.
so.
If it's on record, Your Honor, I rest my case.
I want to just say this. I think I agree with Kelwan on one part. We are all equal before this court.
That's correct, Your Honor.
So let's leave it at that.
That's correct, Your Honor.
Anything else?
Well, the only last issue is the application to examine the inspector, the deponent, in this miscellaneous application. And Your Honor, I would like to take directions on that.
Now I wish I had taken this file to another court. I think this will never end.
Yes, I oppose. They have not stated the provision of law that gives them the authority to cross-examine the IO after we have submitted and relied on his affidavit. They have responded. So we oppose it. They can serve us with the application and the authority so that we also respond adequately. But before that, Mr. Kelwan wishes to respond on matters that they did not raise.
Go ahead, Kelwan.
Yeah.
You know, there's something new that arose in the course of a response by our learned colleagues. That is with regard to these documents, an order from the High Court at Kiambu, which was given a copy yesterday, where the accused person was released on a cash bail of 200,000 anticipatory and a surety bond of 500,000. Your Honor, it's our submission or reply that even though the court relied on this document to consider the accused person on the temporary release on bond yesterday, that this order really have no nexus with this case before you. I would not want to use the word mischief because I would not like it, but there must be a reason why our learned colleagues have deliberately failed to serve the application. We've served the order.
The owner's application was served.
So it's not served.
Stamped.
It is not nexus, that's all.
Yeah, if that is the case, we still insist from reading of this order that there is no nexus and there is no mention of criminal case before you, as well as the criminal case number E715 of 2021. It is not mentioned. And so we submit to the court and abandons this order because it is not related to this case. There cannot be an anticipatory bail, Your Honor, for a case.
Counsel is deliberately misleading the court.
Unless the court.
He is misleading the court. This is not an anticipatory bail. It's a bail that was granted by the court under Article 49. It's not anticipatory.
All right.
Whatever it is,
He's simply saying there is no connection between. And I said it yesterday. I was only going to use that so that we delay the case until today when I was able to deliver the ruling. They are simply saying I should not rely on it. So don't get too agitated. Okay.
Protect Mr. Kelwan, please.
So my submission, Your Honor, as I have said, is that unless or until such a time when our learned colleagues are faced an order relevant to the case before you, this one should not be relied by the Honorable Court. A second issue, which is final about the issue, is relating to the question of explanation as to where the accused person was.
The counsel cannot respond on points of facts. He can only respond on points of law.
There was a question relating to counsel attempted to explain in his own capacity that the accused
Counsel,
person.
you know, we object.
All right,
to
let me
that.
just hear what he wants to say first, and then I'll see if it's a point that if it's not relevant, I promise you I'll not
Because
try.
he can only submit on points of law in his response.
As I said, it's peculiar here today, so
I do not
I
know
think.
why my learned colleague, with due respect, wants to dominate the proceedings.
I have not been.
At some point.
But don't worry, if it's not a point of law, I will not fight it. But at least
You're
let me
most
hear
welcome,
what she
yeah.
wants to say.
So Your Honor, learned colleague has attempted to explain that the accused person sits a number of times, say 3 times per week, and he fails to appear or to attend the parliament for 8 consecutive times, he risks losing the seat. That was his explanation. It's our submission, Your Honor. We reply to that. The accused person in criminal case number E715 of 2021 was represented by counsel. That counsel did not appear in court. He did not write to court.
That is prejudicial to our position because
He did not
we
write
don't
to
have
court.
an opportunity to respond.
He
Those
did-
are matters of facts here.
He did not write a letter to court or to DPP
You know, we object
or
to,
to DCI
may I be heard
Who-
on objection?
or
Just let
DCI
me finish.
who were investigating the case.
May I be heard on the objection, counsel?
Let him finish his point and then I will note your objection.
From 29th of August 2022, nothing, completely, no communication has ever been done to Kiambu law courts, or DPP Kiambu, or even ODPP Nairobi, or DCI headquarters.
Let
to-
me
as to-
object. You can
I can see, those are matters of facts. They are objecting to our
Yeah.
application for cross-examination.
No, yeah, I was concluding with one sentence.
And so the conduct is when one punch is on his feet, the other one
You
sits
don't
down.
follow the conduct, that is why it's also
That's
behaving
the conduct.
I am addressing the court while you are addressing me.
It is important that when he responds, he sticks to the rules.
But he just badge you.
Well, I was concluding
Olunga.
just one sentence by saying, at times that we need to ask ourselves, which one was more important between the accused person, who is honorable member, which one is more important for him to appear before the sittings of parliament or to appear before the court? Which one carries more weight? A question which the court
How
is to
shall we
consider.
respond
That's
to
all.
those
That's all.
facts?
Not obliged. Thank you. Your
You
Honor.
can object. Go ahead and object.
We can only insist that you give us an opportunity to respond to those facts through our petition to cross-examine.
On the last aspect, Ndegwa, you can raise an objection and I will note it down as part of the objection that they actually
Let's move on.
matters of fact. But as written there, these are matters of fact we can't respond to.
The rules of that.
Okay.
Your Honor, to the application for cross-examination,
See, your colleague is responding. That's why I'm saying it's peculiar. We just keep going back.
I'm responding on, I have made that application, so I'm just giving the response. It was suggested that there is no legal provision for cross-examination. And Your Honor, the provision is at Article 50. Article 50, sub-Article 1. K, sub-Article 1K. And what it says, Your Honor, is that an accused person, that's the Constitution. Every accused person, I don't want to read the whole of it, but has a right and a K to abuse and challenge evidence. So, Your Honor, what is before us is an affidavit deponing to matters of fact, together with documentary evidence attached to it, which, Your Honor, we pray that we be given an opportunity to challenge, especially noting that these are matters touching on another proceeding which the court would like to be given the full facts, even the defense, to understand the circumstances so that the court can have the full picture. that application, cross-examination is not prejudicial at all. It only serves the better interest of justice to lay all the facts before the courts. And that's all.
Just want to also look at section 153 of the Evidence Act. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing, and juxtapose it as the submissions made by counsel. Most of that.
Your Honor, I'm not prepared to respond to the application. I have to go and read so that I also guide the court. I cannot stand here and submit on something that I'm not well aware of, because my work as an officer of the court is also to guide the court. So I pray for time to submit, make my submission.
Yona,
It doesn't matter.
Yona, that submission is totally off because we made the application. The DPP responded to our application. We have made a rejoinder. Now, the DPP is saying, wait, give me a second bite of the cherry, let me go research and come back and exercise an existent right of audience. So, you want to kindly make a ruling on the application which you made, responded to, and which you have given a rejoinder.
Cross-examination, right?
Yes.
So before I delve into bail and bond, I first deal the issue of cross-examination.
The cross-examination is on the basis of the affidavit deposed by the DPP, urging the court to deny our client bail. So it is relevant.
Your Honor, maybe just to mention, I really evidenced my colleague, my senior colleague does some research on it. Really, I'm just trying to just think as to really where the proceedings are headed to, because the basis of the affidavit of the inspector, Mr. Makumi, who is in court, is the proceedings. There is nothing new we have introduced. Basically, a chronology of events. Chronology of events showing how the proceedings were conducted up to 29th of August. There is nothing new. So at times we from where we sit, we think that the defense would wish to let the court through unnecessary wastage of judicial time and another whole of proceedings, instead of allowing the court to retreat and make a ruling, which we will abide and respect. So, Your Honor, I think the application should be disallowed. There's nothing new. There's no basis that has been laid really for cross-examination. All the material is before you. And if, in the unlikely event that the court is inclined to allow the application, then we will be praying for time. The officer is informed, he wasn't prepared for it. We are also not prepared for it because we have filed an affidavit which contains everything. Contains everything.
Yeah.
You want to say something again?
We've had a very lengthy deliberations here as defense. And what we realized is that since we started these proceedings yesterday and also today, we've also been a little bit unfair to the court because we really pushed through. There are too many things, and within a limited time, and also we've not been conducting ourselves very well. So, and I apologize.
Broken our system.
You cannot repeat that one. We dissociate ourselves with the submissions made by counsel.
No, there are those instances where we've done what is not presented. So I think just to put it simple, and for the court just to focus on one thing, just the issue of bail.
Okay.
And to our mind, the submissions that you have made with regard to the affidavit. We have no doubt the court will have an opportunity to look at it judiciously. And any fact that is not clear, I'm sure the court will have an opportunity to look at it. So therefore, our submissions with regard to the application for bail and also for cross-examination, we are safe in your hands.
So we're basically withdrawing the application for cross-examination.
We are safe in your hands. Look at the
And only the only thing for the definition is when you granted bail yesterday, and bail be granted on temporary basis.
Or you wanted your client to go in?
No, it's for today's domination.
Yeah, the charge with
As the DPP mentioned, I just gave you reprieve as I did my ruling.
Sure.
So it's not based on that.
Sure.
Don't push it because they will push it too.
What you realize is that the deponent may not be around, and we might have to delay it.
Thank you for saving the course time.
I keep forgetting your name and I need to. So I have still quite a number of matters. As you can see, my resident prosecutor is sitting right there. So again, I think I have to give a date next week for the bail consideration ruling. Unless you're willing to stay here until Saa-nane or something. You take up all our time in these applications in here. We are used to running through the course list. So can you come back on Tuesday, 25th? 25th of February for the ruling on.
You may come in the morning.
What time is morning? Most of you arrive after 10 anyway.
I was here at 10.
At 10. I think 10 is good. Let me go through the call over first.
You can allow the court to clear the list for the day. So that we can
Yeah, let me at least go through the call over. So ruling on the 25th of February 2025 at 10. I will extend the interim bail terms.
Most obliged.
Most obliged.
You know, yesterday I offered to buy this Bunga lunch. They declined. Today I'm still brilliant. The offer is still open.
Anunga will not entertain you until she's done with her. So 25th at
You're
10.
most obliged. See you yesterday.
I hope that's the last application. I want to throw this file.
Tafadhali mpe koti heshima. Koti zingine zinaendelea, please watu watoke nje. Koti inaendelea, please. Yes, some others matters zinaendelea. Sasa hiyo ndio sasa tutaki. Sasa hiyo. Please. We shall overcome. Please. We shall overcome. We shall overcome. Someday.
microphone.
We shall overcome. We shall overcome. We shall overcome someday. We shall overcome. We shall overcome. We shall overcome someday. Ruto will go. Ruto will go. Ruto will go someday. Ruto will go. Ruto will go. Ruto will go someday. Thank you. So,
brief comment.
members of the press, with me, I'm with the senior Maanzo advocate, Mr. Kiragu Adhuta advocate, Mr. Jomo advocate. We are all, and Mr. Mageto Mila advocate, and Ms. Chege advocate. We are all representing the member of parliament for Juja constituency, whom you know that he was arrested for speaking the obvious, that the government has been expending money without accountability, and therefore when he sought to exercise his power to hold the government to account and oversight, he was then accused of having made remarks that did not go very well with those people who do not think that they can be criticized. Those people who still think that we are living in the KANU era. I think the blood is still running thick in their veins. The KANU blood is still running thick in their brain, in their veins. Therefore, today we were coming for the bail application, which you have done. They are saying that Honorable Koimburi should not be admitted to bail for reasons that are baseless and frivolous and vexatious. But the court has been able to admit him to bail, pending a ruling, a substantive ruling on the same matter. And that's why we have him today. As a free man, and that's why we are saying that through the use of the law, we shall overcome all these challenges. May I invite Mr. Maanzo, then invite the others.
The case that he was arrested on
Yes, he was arrested, and that is what surprises us. That when he was arrested on Tuesday, he was accused of cybercrime, that he made verbal pronouncements that, according to the DPP and the DCI, amounted to cybercrime. Only later, yesterday, to change the charges, when they realized that the charges could not attach, that they were baseless, they changed charges and brought trump-up charges against Honorable Koimburi, which we are now facing before this court. All those charges you saw yesterday are charges that the court has sufficiently dealt with in the past. Yeah. So the issues of that he said Mr. William Ruto and his government has spent over 13 billion advocating for Mzee Raila Odinga has been dropped. But the question is, whom does Mr. William Ruto think he is that it should not be questioned? In which country does he think he lives in that cannot question his conduct? This is our money, it's our tax. And we shall continue asking him. Even if they zip Honorable Koimburi, we shall speak and we shall ask, why did you spend our money on Mzee Raila?
Yes, I want to say that the court case originally framed against the member for Juja, Honorable Koimburi, is not what was brought to court. The High Court had already released him on bail. Kamukunji police station disobeyed the High Court and kept him and even brought him here. When we arrived here, they revived an old case which the DPP had withdrawn. That particular case, we are willing to handle it. But that does not make us forget the main reason why Mr. Koimburi is in trouble. I want to encourage the honorable member to make a motion on the floor of the House and question the expenditure which went on in African Union campaign so that the country can know and the Ministry of Foreign Affairs can explain and the Office of the President can explain. Because Kenyans need to know under Article 35 of the Constitution all that information so that Kenyans can know how much of their taxes were spent. This case is just a trumped-up case. We know who started it previously before it was withdrawn. It has no evidence, to be supported in this court, and will be showing that during the trial. And it's just being turned around and being mistreated and prosecuted maliciously, of which if we win the case, we shall sue the state so that it can stop wasting the court's time by political trumped-up cases to mistreat people who question the government as to the expenditures, and this is part of his job to oversight the government. He also one of the biggest things a member of parliament can do to oversight government, and for that matter, National Assembly, is even to move an impeachment motion. So nothing stops him from taking a motion to the House, from questioning the president, from questioning the departments as to the expenditure which went on the African Union.
What has been the ruling today on bail application?
Now, the bail application ruling will be made on Tuesday at 10. He's already been released on bail. The terms of the High Court were adopted by the Magistrates Court, the Chief Magistrates Court, and he's a free man now, but will come on Tuesday to rule, for the court to rule whether the objection to bail can be sustained. And in fact, they have not given any reasons stipulated in the Constitution why he should be denied bail. The only thing Kenya Kwanza is hoping, they are only hoping that he can be denied bail. Then if he doesn't show up in Parliament for 8 consecutive days, then he can be removed as a member of Parliament. So the whole application is political, is unwarranted, and is meant to mistreat the Honorable Koimburi, who is innocent and has denied all the charges against him. The charge, they were trying to say that he was disrespectful to court, has been rejected this morning by the court. It had no basis. It was a frivolous charge and has been rejected. So we go back to the old file, which had already been withdrawn.
We can have
So today we are very happy, and since yesterday we've been here in Kiambu, and today we were heard at length on the bail application. We argued, the DPP came with the arguments why Mheshimiwa should not be released, but the court will do justice. So far, we are comfortable, but going forward, let us not manage politics through the criminal justice system. Let us not do prosecutions of persecution. Let us not persecute people through prosecution. So we will do our best as lawyers. Mheshimiwa, we will support him. And for all Kenyans, we urge you, wherever you are, stay calm. The court will deal with the case judiciously and fairly. Thank you very much.
Mr. Jomo.
Just a minute.
The DPP came with an application to oppose the release of Mheshimiwa on bail. Basically, they are saying this person is not fit to be released on bail. But the High Court on 18th had already admitted him on bail in another application. So Mheshimiwa is fit for bail. So that argument cannot go anywhere. So that is the application that is before the court, and then the court will also set the terms of the bail on Tuesday. But for now, the terms that were given on 18th by the High Court are the ones that have enabled Mheshimiwa to be free. So he's a free man. He obeys court orders. He brought himself today to court, so he cannot abscond court. So let us wait for the court to do its job. We hope, we are sure, we are confident that the court will deal with that matter fairly and justly.
We can have Mr. Jomo next remarks. Then
In just a minute, what we said on Tuesday is that Honorable Koimburi's role as a member of parliament is to oversight government. He has not done any mistake, he has not committed any crime in asking why money was spent wrongly. So that what we want to tell Kenyans is that we have courts, we have a judiciary that is working. Police officers may harass people, the DCI may harass people, but we have seen that today the courts are working. So that people should not fear asking questions, people should not fear criticizing government, because at the end of the day, even if police officers harass us, we have the courts to protect us. Courts are the last resort, and we say thank you to the judiciary for seeing through this so that Kenyans can speak without fear, Kenyans can speak their minds, and at the end of the day, the judiciary is the protector of our rights every day. And the advocates here, we are ready to defend everyone who speaks the truth, because we are not fearing. We have to tell the truth as it is. Thank you very much.
We saw yesterday they plotted for rearrest.
There was that. We don't want to speak much to it, but we are very keen to ensure that justice is done. Even if they arrest anyone today, tomorrow we still come to the court to defend what is right. So that, because what we have seen is that even with orders, they are not willing to comply. But the courts have been very stern that they must obey court orders. So we are hopeful that the judiciary will maintain that, so that at the end of the day, Kenyans will speak, knowing that they have a protector of their rights within the judiciary.
And in any event, for that delay arrest, he is already also again admitted on a discretionary bail. He's also already been freed on bail by the police. So if there is any other charge, we are ready for them.
Thank you, sir.
We
shall overcome. We shall overcome. We shall overcome. We shall overcome someday. Deep in our hearts, we believe. We shall overcome. We shall overcome. Sasa, naenda
Nakota kumunyika. Nakota kumunyika.
Sawa.
All right, kama mnavyotazama, that was the proceeding at the court. Na immediately after the speech, walikuwa nataka kumshika tena, but unfortunately the motorbikes were ready, na hivyo ndivyo ameweza kuondokea. Hey. Cha tuone ni nini inaendelea hapa. I think wamesikia alikuwa anataka kumshika.
Muno, ndio tuikuisia tu. Wewe. Okay. Wacha msosho.
Goja.
Nani neke nawe? Nike nawe. Hii henyari yako.
Hey. That is it. Their plan was to rearrest after they failed to deny them the bail. Now, kama mmesikia, kesi imekuwa scheduled for next week.
Hai. Sasa. Asli? Ah, Safi, thanks. Hata polisi wenyewe hawaamini ameenda. So guys, continue keeping it Mururi TV. Thank you for keeping it here. Next Tuesday we'll be here just to make sure that you're covered and also that we are taking you up to the update of this country. Now, today imekuwa hivyo. So, tuendelee na kazi. If it's your first time, make sure you subscribe.